front as well as on the healthcare front and what have you. The Family First Coronavirus Response Act, as you know, is brand new. As I think many of you know, on today's webinar, the guidance that's provided by the Department of Labor is being pumped out as quickly as possible. I had forwarded some information to a client on Friday and Saturday. If you hadn't seen, on Saturday afternoon, I believe it was, the Department of Labor issued additional guidance. And the fact that the government was actually working on a Saturday should be giving you an indicator of how quickly things are progressing. So today's webinar, I'm going to spend most of the time talking about what this law means and how it applies to your individual operations. I'm certainly looking at the chat box as we go along. If you want to ask a question via the chat, I'll try to monitor the questions and try to answer your question in real time, but I'll also try to reserve some time at the end of today's session to answer questions, but there's a lot of information in a very short period of time. So I will talk about the Family First Coronavirus Response Act. We'll get into the small business exemption to the extent that it may apply. I'll talk a bit about what the emergency paid sick leave means, as well as the emergency, or sometimes you'll hear it as referred to as the Extended Family and Medical Leave Act. We'll talk about the frequently asked questions, and I'll give you a very brief update on some state law unemployment updates. Obviously, the audience is coming from quite a few different states, and we don't have time to get into the nuances of each and every one of your individual unemployment laws. So I'm going to cover it on a very cursory manner, but at least give you some general information. So let's talk first about the Family First Coronavirus Response Act. First point is it becomes effective April 1st, so it's tomorrow. When the act first came out, the law provided that it would take effect no later than April 2nd. So you may have seen or participated in other webinars early last week where the presenters were mentioning April 2nd as the start date. That was clarified by the Department of Labor, so it becomes effective tomorrow. And then also keep in mind that this act, it has a sunset. It expires at the end of this year. The new paid leave requirements I'm going to talk about today, they are not retroactive. So if you've already laid off employees or you have employees that are in quarantine, leave requirements are not retroactive. They take effect April 1st. And under this act, the main provisions impacting employers are the Emergency Family and Medical Leave Expansion Act and the Emergency Paid Sick Leave Act. As you may already be aware, this law is going to provide for quarterly tax credits for employers to offset the cost of emergency paid sick leave and the EFMLA. 100% of the qualified paid sick leave and the EFMLA wages paid are subject to the tax credit. With regard to the IRS, they're pumping out guidance as we speak, and essentially they have said that in addition to the wages that are paid, employers will also be entitled to a tax credit based upon the cost to maintain health insurance coverage for the eligible employee during that leave period. And then it goes without saying that employees who take the emergency FMLA, they're entitled to continued group health coverage during that leave on the same terms as if they were continuing to work for the company. We are still waiting for guidance to come out from the IRS with regard to how the credit will work. But in essence, what we do know is that eligible employers who pay the qualifying sick or child care leave will be eligible to retain that amount of payroll taxes equal to the amount of the qualifying sick or child care leave that has been paid, rather than deposit those funds with the IRS. payroll taxes that are available for retention are fairly broad. It's the withheld federal income taxes, the employee's share of Social Security and Medicare taxes, as well as the employer's share of Social Security and Medicare taxes with respect to all employees. If those taxes are not sufficient to cover the cost of the leave that you're paying out, employers will be able to file a request for an accelerated payment from the IRS. We expect that the IRS is going to process those requests in 2 weeks or less, and we're waiting for the IRS to publish the details of this new expedited procedure. I haven't seen anything yet. I last looked 2 hours ago, so if something has been published this morning, it's brand new, but I haven't seen anything yet. There is a small business exemption for these acts. It's applicable when an employee needs leave because the employee's child's care, place of care, their school, or their caregiver is closed or unavailable. So I'll talk a little bit about what the small business exemption means, but what I want you to be aware of is you may meet the criteria for a small business exemption, but it only applies when the employee needs leave essentially to care for his or her child. That exemption, the small business exemption, does not apply when the employee or the family member is subject to a federal, state, or local quarantine or isolation order, where the employee or family member has been recommended by a healthcare provider to isolate or self-quarantine, or the employee is experiencing symptoms of COVID-19 or seeking a medical diagnosis. One thing that I want to make note of is there's been a lot of questions with regard to whether governor, there are executive orders that are being issued by governors in quite a few states ordering that employees stay home. And the DOL has issued guidance which makes it somewhat clear that these executive orders requesting or requiring employees to stay home are not going to meet the criteria of a federal, state, or local quarantine or isolation order. What they're really referring to is if somebody has been quarantined or ordered to isolate because of exposure to COVID-19 or because they have contracted COVID-19. So in order to apply the Family First Coronavirus Response Act small business exemption, 3 criteria must be met. First, you have to have fewer than 50 employees. Second, the leave, as I said earlier, has to be requested because the child's school or place of care is closed or the child care provider is unavailable for COVID-19 related reasons. And an authorized officer of the business has determined that at least one of 3 qualifying conditions is satisfied. And those 3 conditions are met if the paid sick leave or expanded family medical leave pay would result in the small business's expenses and financial obligations to exceed the available business revenues and cause the small business to cease operating at a minimum capacity. So that's 1. 2, the absence of the employee or employees requesting the paid leave would entail a substantial risk to the financial, health, or operational capabilities of the small business because of their specialized skills, their knowledge of the business, or their responsibilities. And then 3, there simply aren't sufficient workers who are able, willing, and qualified and would be able to work if the leave was provided. So these, as I read these exemptions or these criteria to meet the exemptions, I think they're fairly limited. And I don't think they provide employers as much relief as they were hoping as far as being exempt from the requirements of the Family First Coronavirus Response Act. So let's talk a little bit about the emergency paid sick leave. So the emergency paid sick leave provides that an employee can get 10 days of paid sick leave if they're unable to work due to COVID-19. And employees can use that effective as of April 1st. And it covers all employers under 500 employees. And you'll note that I broke out the under 50 employees. It's going to apply to you unless the small business exemption applies, which is limited. It only applies to individuals seeking leave for the closing of their school or their child care is unavailable. And then you have to also meet the additional 3 criteria. So in essence, it applies to all employers with fewer than 500 employees. The paid sick leave covers all employees, whether they are full-time employees, whether they're part-time employees, and doesn't matter how long they've been working for you. They could start working for you as of yesterday, and they'll immediately be eligible for the emergency paid sick leave. There are also scenarios where, and I don't think it's going to apply to anybody on today's call, but there are scenarios where if an employer is a healthcare provider or an emergency responder, they may elect to exclude employees from the coverage of the emergency paid sick leave. So there are a number of reasons when you're required to pay the emergency sick leave. You're required to pay the emergency sick leave when the employee is unable to work for reasons related to COVID-19. And in essence, there are 6 factors that you look at. You have to pay if the employee is subject to a quarantine or isolation order. The employee has been advised by a healthcare provider to self-quarantine. The employee is experiencing symptoms of COVID-19 and seeking medical diagnosis, or the employee is caring for an individual who is subject to 1 and 2 on this slide. Employees are also entitled to paid sick leave if they're caring for their son or daughter because the school or child care is closed or unavailable. And then you'll see number 6 on this slide refers to the employee is experiencing any other substantially similar condition as specified by the Secretary of Health and Human Services. And we're still waiting for guidance with regard to what the Department of Health, as well as the Secretary of Labor and the Secretary of Treasury, will say as to what do you mean by substantially similar conditions. So we'll have to stay tuned on that. The first 5 on this slide are fairly self-explanatory. The amount of leave that's available is 80 hours for full-time employees, and part-time employees are entitled to paid leave equal to the average number of hours that the employee works over a 2-week period of time. Now, the reasons that the individual takes leave will dictate how much pay they're entitled to. So in some scenarios, the employee may be entitled to up to $511 per day with a cap of $5,110 in the aggregate. And there are other scenarios where they're entitled to 2/3 of their pay, up to $200 per day, and $2,000 in the aggregate. Keep in mind, this is just for the paid sick leave. So in essence, if the way I try to describe it to clients is if the employee is directly impacted, so it's directly impacting the employee's health, they're entitled to the regular pay of up to $511 per day. So if the employee is subject to a quarantine or isolation order, they've been advised by a healthcare provider to self-quarantine, or the employee is experiencing symptoms of COVID-19 and seeking medical diagnosis, they're entitled to the higher amount. If the employee is caring for an individual or experiencing a substantially similar condition, then they're entitled to the lesser amount, 2/3 of their pay, up to $200 per day, and the aggregate of $2,000 in the aggregate for that 2-week period of time. There's been a lot of questions with regard to the emergency paid sick leave and what employers may or may not do. And a lot of these questions are answered in the frequently asked questions issued by the Department of Labor over the last week. But some of the ones that are common questions that have been asked by employers: number one, you cannot require an employee to use other employer provided paid leave first. So what you have to keep in mind is that the emergency paid sick leave is an additional benefit for employees on top of the other leave that is provided by the employer. Employers can't require employees to find a replacement for their shift if they're unavailable. And then another common question is, can we require the employee to follow our notice procedures, such as we would typically do if they were calling in sick or what have you? And the answer is yes, you can require an employee to follow reasonable notice procedures. Including after the employee receives emergency paid sick leave, you can continue to require the employee to follow reasonable notice procedures in order to continue to receive such paid sick time. So keeping you up to speed as to their status and when they expect to return to work. Also, another common question that is asked is, there are 6 criteria when somebody's eligible to receive emergency paid sick leave. Can they use any one of them or a combination of them? And the answer is yes, you can. But the bottom line is they are capped at 80 hours under the Emergency Paid Sick Leave Act. These are some of the more recent questions that are being raised by clients is, what about intermittent leave? For emergency paid sick leave, can they use intermittent leave? And the answer is that unless the employee is teleworking, emergency paid sick leave must be taken in full day increments. So again, unless they're teleworking, they must take the qualified leave in full day increments when the employee is subject to a quarantine or isolation order, when they've been advised by a healthcare provider to self-quarantine, when the employee is experiencing symptoms of COVID-19 and seeking medical diagnosis, as well as when the employee is caring for an individual who is either subject to a quarantine or isolation order or has been advised by a healthcare provider to self-quarantine. Keep in mind that this slide is talking about the emergency paid sick leave. We'll get into a different scenario when we're referring to EFMLA. Additionally, keep in mind that if an employee and an employer agree, so you have to have an agreement, the employee may take emergency paid sick leave intermittently if they're taking the emergency paid sick leave to care for their child when the school or place of care is closed. So as an example, I put on this slide, you may have an employee who their school or place of care is closed for their child, and the employee may take paid sick leaves on Monday, Wednesday, and Friday to care for their child, but work at the normal work site on Tuesdays and Thursdays, and that'd be a scenario where they could take the intermittent paid sick leave for those 3 days that they're unable to work. A number of questions have been raised with regard to, okay, we're going to get a tax credit. So what do we do? How do we, what information is the IRS going to be looking for? And there's a little bit of guidance issued in the Department of Labor's frequently asked questions, but you certainly are going to want to collect as much information as possible. Obviously, you're going to collect the employee's name, the qualifying reasons for requesting the leave, a statement that the employee is unable to work, including telework for that reason, and then any documentation that you can get for substantiating the leave and the dates for which the leave is requested. And that's a minimum of information that you should be gathering. Ultimately, you're probably going to want to have all of that information when you apply for the tax credit. So other documentation that you'd be looking for or should be keeping, a copy of the quarantine or isolation order. It may be a copy of the executive order that closes the school or the child care providers. Maybe it's a notice that's been posted on a government website or it's published in a newspaper. Maybe it's an email from the employee or an official of the school closing the school. Or in the case of where the employee needs to self-quarantine, the written documentation from a healthcare provider. All of this would be good information for you to maintain so that you can support the paying of the sick leave and ultimately obtaining the tax credit in the future. Also keep in mind that you are required to post a notice of employee rights. You should be posting this now because the law takes effect as of April 1st or tomorrow. You can download a copy of this notice or this poster on the Department of Labor website. We have a link on this slide to show you where to keep it. The DOL has also said that you can meet these requirements by emailing the poster to the employees or posting it on the company's external or internal website as well. So this is the poster, and there's one thing that I want to point out because I've gotten quite a few questions from clients, but if you look at this poster under the paid leave entitlements, and look at the third bullet point where it says employees may receive up to 10 weeks more of paid sick leave and expanded family medical leave at 2/3 of the qualifying reason for up to $200 daily and $12,000 total. I've had a number of clients who have asked me where they've said, well, I thought the Expanded Family Medical Leave Act was limited to $10,000 total. And if you read this slide closely, or this poster closely, the DOL is combining the paid sick leave of $2,000 plus the expanded family medical leave at another $10,000 to note the $12,000 total. So if you've been confused on the poster, hopefully that helps explain why they're referring to the $12,000. They're just combining the sick time with the expanded family medical leave. Again, the emergency paid sick leave, it expires as of December 31st, 2020. And if employees don't use the paid sick leave, it doesn't carry into over 2021, and they wouldn't be entitled to it. Questions are asked, well, what happens if we don't pay it out when we're supposed to? Well, the paid sick leave falls under the Fair Labor Standards Act. And under the Fair Labor Standards Act, if you don't pay employees wages or you don't classify them appropriately, you're subject to a possible civil suit. Maybe the Department of Labor gets involved. You could pay double damages. Attorney fees are also a remedy that an employee can receive if you violated the law. Of course, there's civil penalties. And then in some states, there's enhanced laws, such as in Minnesota. Minnesota has the Minnesota Wage Theft Act, which makes it criminal to knowingly not pay employees wages that are due and owing. And so if you don't pay the paid sick leave when you're supposed to, not only are you facing, a wage and hour claim, which allows for all these remedies, but in addition, you could face criminal proceedings as well if you intentionally refuse to pay employees something that they're entitled to under federal law. The next piece of the Family First law is the Emergency Family and Medical Leave Expansion Act. And once again, the EFMLA is in place for the same time period. It's in place until December 31st, 2020. And I want you to keep in mind that with regard to the EFMLA, it is only available when an employee is unable to work or telework to care for a minor child if their school or licensed child care is unavailable due to a public health emergency. So if your schools have been closed down by the governor and you're unable to work or telecommute, you'd be entitled to the benefits under the EFMLA. Son and daughter is defined as under the traditional Family Medical Leave Act, which includes biological, adopted, foster children, a stepchild, a legal ward. It includes children under the age of 18, as well as a child over the age of 18 if they're incapable of self-care because they have a physical or mental disability. The EFMLA applies to covered employers with fewer than 500 employees. And again, you'll note that there's a small business exemption if you're under 50 employees. With regard to the EFMLA, it includes anyone who's been employed by the company for 30 days or longer. It includes part-time employees, and there is an exception for healthcare providers or emergency responders who can elect to exclude such individuals from coverage, but I don't think that applies to anybody on today's call. EFMLA, the length of protected leave is 12 weeks. Keep in mind that if you fall under the Family Medical Leave Act and you have employees who have already used some of their 12 weeks of allotment under the Family Medical Leave Act, they only get a total of 12 weeks under the FMLA and the EFMLA. They don't get 12 and 12. The maximum leave that they get is 12 weeks. So if they took, as an example, if they took 8 weeks for the birth or adoption of a child under the FMLA, and they're still in the 1 year period of time, the most that they would get under the EFMLA is 4 additional weeks. And this slide talks about that issue that I just referenced. The CARE Act, many of you have heard that there was legislation that was passed on Friday with regard to the CARE Act, which has obviously quite a few subsidies, opportunities for employers or businesses to take loans, which is outside the topic of today's webinar. But the CARE Act also updated the definition of a covered employee. And essentially what it provides is that rehired employees are going to be covered under the EFMLA. So if you have an individual who worked for you for at least 30 days and then they were laid off and then they're rehired, the EFMLA is going to apply to them. So benefits that are available under the Emergency Family Medical Leave Act. Paid leave, the first 2 weeks, the first 2 weeks or 10 working days is unpaid. Of course, under the EFMLA, employees can substitute emergency paid sick leave, which we've talked about, paid time off, or vacation. And there very well may be scenarios where somebody takes the sick leave first and it's unrelated to child care, right? They have to self-quarantine. And so they take the 2 weeks of paid sick leave for being self-quarantined. And then the child's school closes or a child care provider is unavailable. And in those instances, then the employee can take 10 weeks, they can take 12 weeks of EFMLA with the first 2 weeks being unpaid unless they have PTO or vacation to use, because in the example I provided, they would have already exhausted their emergency paid sick leave. But under the EFMLA, the employees are entitled to 10 weeks of pay. The 10 weeks of pay is based upon their regular rate of pay. So it's 2/3 of their regular rate of pay for up to $200 per day or $10,000 in the aggregate. You may have employees who work variable schedules, and if you're determining the pay for employees with variable schedules, essentially what you're going to need to do is determine the average number of hours that the employee was scheduled per day, including leave time such as PTO, over a 6-month period ending on the date in which the employee takes the EFMLA, and come up with that average number of hours. If the employee has not worked 6 months, then the rate of pay is essentially going to be based on the reasonable expectation of the employee at the time of hiring of the average number of hours per day that they would typically be scheduled to work. Under the EFMLA, employers may allow intermittent leave, but they're not required to do so. So as an example, let's assume that an employee is prevented from teleworking their normal schedule because of the hours that they need to work or that they need to care for their child. They're unavailable. The employer and the employee may agree that the employee can take expanded FMLA intermittently while teleworking. For the same reasons as sick pay, you should be documenting the reasons somebody is taking EFMLA, and that includes gathering the employee's name, a statement that the employee is unable to work, including telework for that reason, and then of course documenting the reasons for the leave. And we've talked about these reasons previously when we talked about sick leave. One thing to keep in mind is that with regard to the EFMLA, employees have the right to return to the same or equivalent position when they return to work after taking emergency family medical leave. There are some exceptions to that general rule, and that exception is that if you're an employer with fewer than 25 employees when the employee take their emergency leave, if all of the following reasons apply, then you do not have to return them. So as an example, the position no longer exists because of economic conditions. You make a reasonable effort to return the employee to another equivalent position. And if you're unable to return the employee to equivalent position, you make a reasonable effort to contact the employee for 1 year, beginning on the end of their qualifying need, or 12 weeks after the employee's leave began. So you're going to have to continue to contact them for a 1 year period if you're unable to return them to work. Another nuance with EFMLA is if you're an employer with fewer than 50 employees, your employees do not have a private cause of action against you to sue you for a violation of the EFMLA, but the Department of Labor may still investigate and sue the company on the employee's behalf. So here's some frequently asked questions about this new law. And again, I highly recommend that if you haven't, that you go to the Department of Labor website and look at the frequently asked questions. I think they're up to 58 or 59 now of frequently asked questions. And they're pretty detailed. They provided a great amount of information and answered quite a few questions that I'm certain a number of you have on this webinar. So I'm going to cover some of the ones that were being asked by our clients on a regular basis. So if an employer is open but furloughs an employee on or after April 1st, can the employee receive emergency paid sick leave or the EFMLA? And the answer is no. So if you're open but they're furloughed, they're not entitled to the benefit because they wouldn't be working. If an employer closes a work site before April 1st, can employees still get the emergency paid sick leave? Again, the answer is no. They're not entitled to it. Another question is, what happens if we close our work site on or after April 1st, but before an employee goes out on leave? Can the employee still get one of these benefits? And the answer again is no, they're not entitled to it. If an employer closes a work site while the employee is on the paid sick leave or EFMLA, what happens? And if you close your business or your work site while an employee is on paid sick leave or EFMLA, you're required to pay the paid sick leave and the EFMLA used before you closed. However, after you close that work site, the employee is no longer entitled to receive the emergency paid sick leave or the EFMLA. Another common question that we're getting is, if an employer reduces an employee's scheduled work hours, can the employee use emergency paid sick leave or EFMLA for the hours that the employee is no longer scheduled to work? Excuse me. And again, the answer is no. If the employer reduces the work hours because it doesn't have enough work for an employee to perform, the employee can't use emergency paid sick leave or EFMLA. Another question that's coming up, particularly since there's been an introduction of the teleworking into the frequently asked questions, is what does it mean to be unable to work? And essentially it means that an individual is unable to work if their employer has work for them and one of the COVID-19 qualifying reasons set forth that we talked about earlier prevents the employee from being able to perform work either under normal circumstances at the normal work site or by means of telework, okay? It's a lot of information in a short period of time with regard to the Family First Law. Additionally, we have a brief update on state unemployment laws. And again, I know that some of our attendees are coming from, I believe, 5 different states. So I'm going to cover this in a very cursory manner, but hopefully it'll provide you a little bit of guidance. The first is the CARES Act. The CARES Act, which came into existence on March 27th, which is a federal law, essentially will pay employees $600 per week for 26 weeks on top of the state benefit. It's will also be expanded to an additional 13 weeks at $600 per week if the state limits its unemployment benefits to a 26-week period of time. If your state waives the 1-week waiting period to receive benefits, the CARE Act benefits commence immediately. And the requirement to search for suitable employment does not include employment that puts the health and safety of an applicant at risk or employment that puts the health or safety of other workers at risk. In Minnesota, just to get into some Minnesota laws, and we'll get into the other states here in a moment, it suspended the 1-week waiting period for unemployment benefits between March 1st and December 31st. The requirement to search for suitable employment does not include employment that puts the health or safety of an applicant at risk. And under Minnesota, recipients for unemployment do not need to actively seek suitable employment that puts their health or the safety of others at risk. The governor's order can be viewed at the link below. Iowa, I think there's a few of you from Iowa. All employment claims filed and paid as a result of COVID-19 will have the charges waived for employers. By the way, that's the same in Minnesota. If you're paying out the benefits, it's not going to be charged against you. Employees no longer need to use paid time off first before obtaining unemployment benefits, which was a requirement. And if an employee is required to self-quarantine for 14 days, they're eligible for unemployment benefits. North Dakota, same thing. All unemployment claims filed and paid as a result of COVID-19 will have the charges waived for employers. The search requirement is waived. The waiting period is suspended as well. More information can be found on the link below as it relates to North Dakota. South Dakota, again, no obligation to actively seek work while seeking benefits or while receiving benefits. Employees are eligible for benefits if they test positive for COVID-19. If a worker is out of work because the employer closed because of COVID-19, a worker has hours reduced because of a reduction in force, or if a worker is sent home because the employer thinks they are at risk, they're likely eligible for benefits as well. Nebraska, again, no obligation to actively seek work while receiving benefits. They've also suspended the waiting period and they're granting relief to employers, so you're not being charged for benefits that are being paid out through unemployment. So a lot of information in a very short period of time. I'm certain that you have a number of questions. I see that there's some that are popping up already. Question is, how do small employers with less than 50 employees apply for an exemption from the EFMLA as well as the child care aspect? And I think we talked a little bit about that during the course of today's webinar. Are there other questions? Another question is raised, do we know what type of tax exemptions can be used to offset the EFMLA? Is it FICA or, and as I indicated at the beginning of the presentation, they have clarified that it's beyond just the FICA. They're essentially covering all the payroll taxes that you're essentially paying out to employees, or that, not that you're paying out to employees, but that you're paying into the IRS, including the employer portion of Social Security. So you're getting that full exemption. And if you don't get, if all the payroll taxes that you're paying out do not cover the cost of the paid sick leave or EFMLA, there's going to be an expedited process for you to recoup those dollars. Does a disabled adult dependent qualify for the child care aspect? And the answer is yes. Under the EFMLA, FMLA is if you're responsible for caring for a child over the age of 18 who has a physical or mental impairment, you will qualify for those benefits to care for them. Another great question, and I forgot to mention this, and I've had a lot of employers ask me this question, and that question is, could a laid off worker actually make more money collecting unemployment benefits than working? And the answer is yes. And I'm disappointed to give you that answer because the federal government has, in essence, given employees a disincentive to go back to work or to seek gainful employment. And so the answer is yes, they could actually make more as a result of the CARE Act because they're receiving, depending on the state, they could receive up to 2/3 of their wages through the state unemployment, but they get an additional $600 per week, and that is a flat amount. They get an additional $600 per week up to 26 weeks for the federal benefit on top of that. Other questions that you may have on this webinar?
Tom, this is Chris. I think a few more people have they've sent me questions that I've been trying to then send to you. And then, so I wasn't there. One of them was asking about links. I know that we have links in the PowerPoint presentation,
Yep.
but they said, or samples of forms for employers, employees to use. Did you answer that one while I was typing?
Yeah, I mean that's a pretty broad question with regard to written policies and procedures. And I guess what I would suggest is if you fall under the FMLA already, it would make sense for you to update your FMLA policy to include the expanded FMLA. With regard to if you are, you typically wouldn't fall under the FMLA, you certainly have the poster that's going up to, or being distributed electronically to employees to advise them of their rights under these two different buckets of leave, so to speak. And certainly you can develop a policy if you so desire to notify employees of these leaves. I have clients that have in essence drafted letters to their employees to notify them, or they've had meetings with their employees to advise them of what benefits they may receive under these different scenarios. So great question, but I wouldn't say that I have sample forms. Additionally, and the reason we don't have sample forms yet is I anticipate that we're going to see some sample documents from the Department of Labor in the near future with regard to, some of the information that you may obtain from employees. Much like for those of you who are on today's call, you're probably familiar with the forms that the Department of Labor has published for the Family Medical Leave Act. I fully anticipate that they would update those forms such that they also apply to EFMLA. Again, this law has been in existence for about 10 days now, so things are moving fairly quickly. And I think the government is pushing out guidance as quickly as they can. And I suspect that over the next week or two, you're going to see more information about these two different leaves. I suspect we're going to see some sample forms published by the Department of Labor. And obviously it goes without saying that the IRS is going to be issuing additional guidance as well on how to apply for that exemption, or certainly how to get the expedited payments if your payroll taxes aren't covering the sick pay that you're paying out.
Okay, well, Tom, thank you so much for sharing this presentation today. We will make this recording available to all the participants later on today, along with the PowerPoint presentation. Like I said, thank you for participating, and look out for new opportunities and information from PIM. You can visit our website at pimw.org to find a lot of information to help our printing industry Midwest employers out. And I think that's all for today.
Thanks, everyone.
Thank you. Bye-bye.